VCA. Facts: Merlita Cardino is the owner of a parcel of land in Sitio Sto, Nino, Alaska Mombaling. The city of Cebu filed a complaint for eminent domain against Cardino with the RDC seeking to expropriate the said parcel of land. The complaint was initiated pursuant to Resolution No. 404 and Ordinance No. 1418, dated February 17, 1992. Of the Sangguniang Panlungsod of Cebu City authorizing the city mayor to expropriate the said parcel of land for the purpose of providing a socialized housing project for the landless and low-income city residents. Cardino filed a motion to dismiss on the ground of lack of cause of action as there has been negotiations for the purchase of the property without resorting to expropriation, but said negotiations failed. Also, there was no compliance with the conditions to the exercise of the power of eminent domain. The RDC dismissed the complaint. The CA affirmed the of the RDC. According to the CA, an allegation of repeated negotiations made with the private respondent for the purchase of her property by the petitioner, cannot by any stretch of imagination be equated or likened to the clear and specific requirement that the petitioner should have previously made a valid and definite offer to purchase. It further added that the term negotiation, which necessarily implies uncertainty, it consisting of acts the purpose of which is to arrive at a conclusion, may not be perceived to mean the valid and definite offer contemplated by law. Issue 1. Expropriation may be granted ratio. An offshoot of the foregoing is the instant petition for review on certiorari, which has essentially become a battle of semantics being waged before this court. While petitioner reiterates that paragraph 7 of the complaint sufficiently states compliance with the requirement of a valid and definite offer, private respondent insists that the term negotiations is too broad to be equated with the said requirement. Elaborating, private respondent posited that by definition, negotiations run the whole range of acts preparatory to concluding an agreement, from the preliminary correspondence, the fixing of the terms of the agreement, the price, the mode of payment, obligations of the parties may conceive as necessary to their agreement. Thus, negotiations by itself may pertain to any of the foregoing and does not automatically mean the making of a valid and definite offer. At the outset, it must be said that without necessarily delving into the parties' semantical arguments, this court finds that the complaint does in fact state a cause of action. What may perhaps be conceded is only the relative ambiguity of the allegations in paragraph 7 of the complaint. However, as we have previously held, a complaint should not be dismissed upon a mere ambiguity. Indefiniteness or uncertainty of the cause of action stated therein, for these are not grounds for a motion to dismiss but rather for a bill of particulars. In other words, a complaint should not be dismissed for insufficiency unless it appears clearly from the face of the complaint that the plaintiff is not entitled to any relief under any state of facts which could be proved within the facts alleged therein. The error of both the RDC and Respondent Court of Appeals in holding that the complaint failed to state a cause of action stems from their inflexible application of the rule that when the motion to dismiss is based on the ground that the complaint states no cause of action, no evidence may be allowed and the issue should only be determined in the light of the allegations of the complaint. However, this rule is not without exceptions. In the case of Tan v. Director of Forestry, this court departed from the aforementioned rule and held that, although the evidence of the parties were on the question of granting or denying the petitioner-appellant's application for a writ of preliminary injunction, the trial court correctly applied said evidence in the resolution of the motion to dismiss. Likewise, in Mark Opper Mining Corporation v. Garcia, we sanctioned the act of the trial court in considering, in addition to the complaint, other pleadings submitted by the parties in deciding whether or not the complaint should be dismissed for lack of cause of action. This court deemed such course of action but logical where the trial court had the opportunity to examine the merits of the complaint, the answer with counterclaim, the petitioner's answer to the counterclaim and its answer to the request for admission. The same liberality should be applied in the instant case. Furthermore, even on the face of the complaint alone, there is extant a cause of action. All documents attached to a complaint, the due execution and genuineness of which are not detained under oath by the defendant, must be considered as part of the complaint without need of introducing evidence thereon. Additionally, the general rule is that a motion to dismiss hypothetically admits the truth of the facts alleged in the complaint. Thus, Ordinance number 1418 is not only incorporated into the complaint for eminent domain filed by petitioner, but is also deemed admitted by private respondent. A perusal of the copy of said ordinance which has been annexed to the complaint shows that the fact of petitioners having made a previous valid and definite offer to private respondent is categorically stated therein. Thus, the second whereas clause of the said ordinance provides as follows: whereas the city government has made a valid and definite offer to purchase subject lot for the public use aforementioned, but the registered owner Mrs. Merlita Cardino has rejected such offer. The foregoing should now put to rest the long-drawn argument over the alleged failure of the complaint to state a cause of action. There is no longer any room for doubt that is alleged in the complaint, and as admitted by private respondent, the petitioner had in fact complied with the condition precedent of a valid and definite offer set forth in Sector 19 of RA 7160. The rules of procedure are not to be applied in a very rigid, technical sense. Rules of procedure are used only to help secure substantial justice. If a technical and rigid enforcement of the rules is made, their aim would be defeated. Where the rules are merely secondary in importance or made to override the ends of justice, the technical rules had been misapplied to the prejudice of the substantial right of a party, said rigid application cannot be countenanced. The doctrine finds compelling application in the case at bench. For as correctly averred by petitioner, nothing else was accomplished by the dismissal of the complaint for eminent domain but a considerable delay in the proceedings. The dismissal of the complaint did not bar petitioner from filing another eminent domain case and from correcting its alleged error by the mere expedient of changing paragraph 7 thereof. Indeed, precious time has been wasted while the salutary objectives of Ordinance number 1418 of the City of Cebu have been put on hold by a quarrel over technical matters. Francia v. Mun of Makoian. Facts: on February 6, 2003, the respondent filed a complaint for expropriation against petitioners. Respondent needed petitioners 16,256 SQM. Idle property at the junction of the North Expressway, Malhakaniba-Kamali Main Road Artery and the MacArthur Highway. It planned to use it to establish a common public terminal for all types of public utility vehicles with a weighing scale for heavy trucks. In their answer, petitioners denied that the property sought to be expropriated was raw land. It was in fact developed and there were plans for further development. For this reason, respondents' offer price of P2,333,500 was too low. After trial, the RDC ruled that the expropriation was for a public purpose as the terminal would improve the flow of traffic during rush hours. Moreover, the property is the best site for the proposed terminal because of its accessibility. Aggrieved, petitioners filed a petition for certiorari in the CA. They claimed that the trial court issued the orders without conducting a hearing to determine the existence of a public purpose. The partially granted the petition. Finding that petitioners were deprived of an opportunity to controvert respondents' allegations, the appellate court nullified the order of expropriation except with regard to the writ of possession. According to the CA, a hearing was not necessary because once the expropriator deposited the required amount, the issuance of a writ of possession became ministerial. Issue 1. The CA erred in upholding the RDC's orders that, in expropriation cases, prior determination of the existence of a public purpose was not necessary for the issuance of a writ of possession. Held no ratio, Section 19 of Republic Act 7160 provides. Section 19. Eminent domain. A local government unit may, through its chief executive and acting pursuant to an ordinance, exercise the power of eminent domain for public use, or purpose, or welfare for the benefit of the poor and the landless. Upon payment of just compensation, pursuant to the provisions of the Constitution and pertinent laws, provided, however, that the power of eminent domain may not be exercised unless a valid and definite offer has been previously made to the owner, and that such offer was not accepted, provided, further, that the local government unit may immediately take possession of the property upon the filing of the expropriation proceedings and upon making a deposit with the proper court of at least 15% of the fair market value of the property, based on the current tax declaration of the property to be expropriated, provided, finally, that the amount to be paid for the expropriated property shall be determined by the proper court, based on the fair market value at the time of the taking of the property. Before a local government unit may enter into the possession of the property sought to be expropriated, it must file a complaint for expropriation sufficient in form and substance in the proper court and deposit with the said court at least 15% of the property's fair market value based on its current tax declaration. The law does not make the determination of a public purpose a condition precedent to the issuance of a writ of possession.